Thank you, Mr. Speaker. I'm well guided. I will try within my ability to utilize the 15 minutes. Where need be, I will come back to your Honorable Chair and ask for extension of time. Otherwise, I thank you for this opportunity, Mr. Speaker. Mr. Speaker, this is a very interesting day. Mr. Speaker, as I was presiding over the proposed impeachment of Governor Anne Waiguru, some funny people were hiding in some cocoon, planning to remove me.
Order, Senator Malala.
As Senator for Kakamega.
Order, Senator.
It is quite ironical.
No, order. Can you use your time properly?
Thank you.
You are now dragging the House into your party issues, and we are not party to that. Please focus on your
Thank
report.
you. I want to remind the people that I am the Senator for Kakamega, and I'll stay to be the Senator for Kakamega. Mr. Speaker, sir, permit me to begin by remarks conveying on behalf of honorable senators of the Special Committee on the proposed removal from office of the Governor for Kirinyaga County, our appreciation and gratitude to you and this Honorable House for the confidence you expressed in us to undertake the honors task by appointing us to serve in this special committee. Mr. Speaker, pursuant to Section 33(3)(b) of the County Government Act of 2012 and Standing Order number 75(1)(b) of the Senate may, by resolution, appoint a special committee comprising 11 of its members to investigate the matter or investigate the matter in plenary. Mr. Speaker, the Senate Majority Leader moved a motion on Tuesday, 16th June 2020, and following the debate in the House, the Senate resolved to establish a special committee comprising of Senator Abshiro Alake, Senator Michael Mbito, Senator Mwangi Paul Githiomi, Senator Beth Mugo, Senator Anwar Loitiptip, Senator Philip Mpayae, Senator Cleophas Malala, Senator Beatrice Kwamboka, Senator Stuart Mazayo, Senator Judith Pareno, and Senator Moses Kajwang, to investigate the proposed removal from office by impeachment of the Governor of Kirinyaga County and to report to the Senate within 10 days pursuant to Standing Order 75(2) of its appointment on whether it finds the particulars of the allegations to have been substantiated or not. Mr. Speaker, following its establishment, the Senate committee held its first meeting on Wednesday, 17th, 2020, pursuant to Standing Order 193 and Rule 3A of Part 2 of the 5th Schedule of the Senate Standing Orders. The Clerk of the Senate conducted the election for position of chairperson and vice chairperson. Mr. Speaker, I wish to report that the committee elected the Kakamega Senator, the one Senator Cleophas Malala as the chairperson, and Senator Abshiro Alake, MP, as the vice chair. Mr. Speaker, sir, Section 33(5) of the County Government Act, Standing Order 75(3) and Rule 4A of Part 2 of the 5th Schedule of the Senate Standing Orders provide that the governor shall have the right to appear and be represented before the special committee during investigation. Rule 4B of Part 2 of the 5th Schedule to the Senate Standing Orders further accord the County Assembly the right to appear and be represented before the special committee. Mr. Speaker, the committee commenced its hearing on Wednesday, 24th, 2020, by convening a conference of parties where formal introductions of parties, recital of the mandate, and the committee adoption of the hearing program took place. Mr. Speaker, among the preliminary issues that the committee had to deliberate and make a decision on was a letter, Mr. Speaker, referenced Senate Letter 1/003 dated 20th June 2020 from the Speaker of the County Assembly of Kirinyaga requesting the special committee to summon Mr. Patrick Mugo, the Chief Officer, Finance and Economic Planning, Mr. Kennedy Ngiabi, the Chairperson, County Public Service Board, and Mr. Joseph Otieno Karilas, the Director, Supply Chain Management. The County Assembly stated in its letter that the said officer had refused, neglected, or otherwise been unable to give their statements and produce documents requested by the County Assembly. The committee deliberated on the matter and pursuant to Rule 9 of Part 2 of the 5th schedule of the Senate Standing Orders, issued invitation to appear as witnesses. The invitation to appear was served on the witnesses on the same day. Mr. Speaker, the County Assembly was represented by Mr. Ndegwa Njiru and Mr. Charles Mwangi Ndegwa, and the Governor was represented by Mr. Paul Nyamodi, Advocate, Mr. Kamotho Waiganjo, Advocate, and Andrew Muchiri Karani, Advocate, to appear on behalf of the Governor. During the...
This is a point of order.
The Speaker, I didn't mean to interrupt Senator Malala, but to start with, Mr. Speaker, is making comments pursuant to your generosity and on application of Standing Order number 1. Ordinarily, we would not have gone this direction. The matter would have ended and we go home. And since he's doing so, you say that because of the importance of the impeachment of governor, I would suggest, Mr. Speaker, with your direction, that Senator Malala forgets about all this introduction, about who is a member of the committee, when did it start, who are the lawyers, who are the parties, and then go to the substratum, Mr. Speaker, the real issues that happen, so that then we can apply this short time, this window you've created, for purpose of the salient issues. Otherwise, his time will be wasted on things that we know. We know there is a governor, there was an MCA, there were lawyers, there was hearing, there was hard this. Let him just go to, this is the things the committee faced as challenges, and they ended up making this recommendation because of this. That way, we will use this time more quality than the recitals he's making. The rest we can read for ourselves.
Okay, Senator Malala, utilize your time properly, the 15 minutes.
Mr. Speaker, you've given me 15 minutes. It is my prerogative to know how to use the 15 minutes. You cannot limit me on the time and again tell me how to spend the 15 minutes. So, Senator Murkomen, kindly allow me to discharge my duty as the chairperson of the Select Committee. Mr. Speaker, sir, I will go directly to the charges against Governor Anne Waiguru. There were two main charges leveled against the governor, which are gross violation of the Constitution and other laws, and abuse of office and gross misconduct. To support the first charge, the County Assembly made the following allegations. 1, failure to deliver the annual State of the County Address for financial year 2018-2019 to the County Assembly. 2, undermining the authority of the County Assembly. 3, violation of Public Procurement and Asset Disposal Act 2015 and the Public Finance Management Act of 2012. To support the second charge of abuse of office and gross misconduct, the County Assembly made the following allegations. 1, violation of Section 46 of the Public Procurement and Asset Disposal Act. 2, improper conferment of a benefit on a public officer. 3, disregard of the recommendation of the County Public Service Board regarding the remuneration of members of the Board of Kirinyaga Investment Authority, payment of KIDA board members outside the IFMIS and county government payroll, and payment of interest amounting to more than 14 million paid to Mr. Francis Muriithi Kariuki. And lastly, violation of the right to health of the people of Kirinyaga. Mr. Speaker, allow me to address this House on the issue of the threshold that is required to impeach the governor. The issue of the threshold for impeachment is complex and does not contain a simple mathematical formula. During the Senate's consideration of the report of the special committee investigating the removal of the governor of Kericho, on 3rd June 2014, the Senate adopted the committee's recommendation that the threshold for impeachment should take into account the following consideration. 1, the allegation must be serious, substantial, and weighty. 2, the violation must be a flagrant and glaring violation. 3, there must be a nexus between the violation and the governor. 4, the violation must have led to harm, loss, or damage to society. And lastly, Mr. Speaker, the violation must have led to a loss of dignity in the office held and loss of confidence or trust in the person holding office to carry out the functions of that office with integrity and accountability. The threshold was also used by the Senate in the subsequent consideration of the proposed removal from office by impeachment of Honorable Mwangi Wairiya, the governor of Murang'a County, in November 2015. This special committee adopted the above threshold for removal of Governor Anne Waiguru as adopted by the Senate on 3rd June 2015. Mr. Speaker, in the course of its investigation of this matter, the special committee has observed a number of issues which, though outside the specific charge.
What's your point of order?
Mr. Speaker, Senator Malala has made a very serious statement about the Senate adopting particular criteria in the case of Kericho in 2014 and subsequently in the case of Murang'a. It would be erroneous if it goes to the public that, Mr. Speaker, the Senate adopted any of that procedure, because it was not the Senate. The Senate did not have the opportunity, because the governors were cleared, to adopt any of those procedures. Contrary to his assertion, it is actually the committee in its report that came up, Mr. Speaker, with that criteria, which report was not adopted by the House because Section 33 of the County Government Act does not allow the House to adopt. If it goes to the public out there that there is a set criteria by this House based on those two reports of Kericho and Murang'a, it will create the impression that this particular committee found itself a cover to come and explain the clearance of the governor using a report of a committee which was not adopted by this House, but rather which was used by the committee, a criteria used by the committee to clear certain governors. So I'd like, Mr. Speaker, to you to rule whether it is in order for Senator Malala to use the word adopted by the Senate instead of saying used by the relevant committee.
Senator Malala, I think it's a matter of semantics. Semantics, you know.
Mr. Speaker, in English, we have what we call synonyms. So you'll allow me today to please my friend, Honorable Murkomen, to use a synonym for adopted. So I will say that the committee did not adopt, but the committee used the precedents of the previous committees. That is what we call synonym in English. In the course of its investigation of this matter, the special committee has observed a number of issues, which, though outside the specific charges made against Governor of Kirinyaga, are garment to the totality of the situation of Kirinyaga County and merit the attention of the Senate. Mr. Speaker, sir, the committee observes that the proceedings before it has exposed acrimonious, contemptuous, and cold relationship between the county assembly on one hand and the county government on the other, and the county governor, on the other hand, that threatens to grind the county
Senator
to a halt.
Cherargei, where are you? What's your point of order?
Because this house is a house of record, it was very important that you make yourself pronounce on the ruling on whether we can, in the past, because there are many reports that are never adopted in this house, that we can use as a threshold, because the perception we are creating is that Senate has its own criteria that is not within the standing orders or the Constitution or the county government, that is being used as a cover by this special committee. So, Mr. Speaker, it's important you rule so that it goes to records, because it's important for us and the future generation. I thank you.
Okay, I think Senator Malala has explained himself and cleared. So he has said, he has avoided saying it adopted the report and said it used the previous precedents. So let us proceed, Honorable Senator. Senator Murkomen.
Mr. Speaker, the point of orders exists for a particular reason in this House. And so it must not look like we are being irritated or we are irritating people by raising these issues. Senator Malala, in his reading of Kericho and Muranga, and the record bears me witness, Mr. Speaker, said we use the criteria adopted by the Senate, not the committee. And I explained myself very clearly, Mr. Speaker, that where governors have been cleared, like the case of Kericho and Muranga, the committee report was not adopted by this House. Therefore, that criteria is not a criteria of the Senate. He will be right if he confines himself to say, we borrowed or adopted. I don't mind him using the word adopted, and he should not teach me about what synonym is. He can say, we adopted a criteria used by the committee in Kericho and Muranga, but not Senate. Because if you say a criteria adopted by the Senate, you create that impression that there's a criteria adopted by this House.
Senator Bogisho. Senator Bogisho.
Speaker, this is really on procedure now. Because I think there's a threshold also, Speaker, on what the point of order is. I mean, you can't use a point of order, Mr. Speaker, to start debating the matter or even argue. I think, Mr. Speaker, I think if we keep ourselves to the threshold, I think we will not have all these things. And I understand what it is. But you can't use that provision to continue debating the issue out of this thing.
Senator Mutula Kilonzo Jr.
Mr. Speaker, this is a very strange argument coming from a lawyer, number one. Two, a person who was the majority leader of this House. And three, the person who takes pride in the drafting of the County Governments Act. Mr. Speaker, under Article 124, and I want to read so that Senator Murkomen can allow the proceedings of this House to continue. Each House of Parliament may establish committees and shall make standing orders for the orderly conduct of its proceedings, including the proceedings of its committees. In simple English, Mr. Speaker, the orderly conduct of this Senate and its plenary and committees is the conduct of Parliament. And therefore, somebody who has been elected since 2013 cannot purport, Mr. Speaker, and pontificate, Mr. Speaker, that the conduct of a committee...
Senator Murkomen, please.
Yes. And Mr.
Please.
Yes. And Mr. Speaker, you must restrain Mr. Murkomen, Senator Murkomen, because he cannot interrupt us, and we are not bystanders in this Senate. Some of us got more votes than him. If we want to brag, we can brag. But he must listen. The Constitution is very clear that our committees are committees of the House. And the conduct of those committees is the conduct of the Senate. Similarly, Mr. Speaker, in Article 125, that is why we have given the mandate of the committees to act as a court under Article 125. It's a committee. Why is Mr. Murkomen behaving like a stranger in Jerusalem? Thank you, Mr. Speaker. Dismiss that objection.
Senator Orengo.
Mr. Speaker, I'd really plead with you again that we must have some form of debate in the Senate. If there's interruption in the middle of speeches, there will never be any debate. In fact, we have rules of debate because we conduct our business and make decisions on the basis of a debate. Now, with this serious agenda which is before us, if Mr. Malala cannot be given time to present the report that he has a summary on a matter in which you are given us the courtesy to comment on it, otherwise business would have ended. But you have given us the opportunity to comment. And Mr. Speaker, I want to remind Senator Murkomen that the first impeachment that we had in this House, he was there with me. And the impeachment twice went through the High Court, it went through the Court of Appeal, it went through the Supreme Court. In fact, the principles and the threshold that Senator Malala read out here was not really what we adopted. It was a direction by the Supreme Court. In petition number 1 of Kerugoya, which was adopted in the Court of Appeal, up to the Supreme Court, the Wambora case, the threshold set out by Mr. Malala was not set by the Senate. In fact, if you go to that report, they were saying they were following the directions of the Supreme Court, the Court of Appeal, and the High Court. And therefore, the committee adopted it on the basis of a judicial decision. And that judicial decision is binding on the House, not just on the committee. It's binding on the House. So,
Honorable Senators.
Mr. Speaker, what I'm appealing to you is that let us have a serious debate on this matter. Mr. Murkomen will also have his time. And if you interfere with him the same way he's interfering with Mr. Malala, he'll not have even a minute to speak.
Okay, order, members, order. Senator Malala, proceed. Murkomen, please, you are pushing me to the edge. Yeah, you are pushing me to the edge. You are not going to tell me what to do. Murkomen.
Mr. Speaker, you'll allow me to proceed, Mr. Speaker. Mr. Speaker, before I was rudely interrupted, I was addressing the issue of the toxic relationship between Governor Anne Waiguru and the County Assembly. In this respect, cognizant of the Senate's role as the custodian of the interests of the counties and their governments, the committee recommends that the Senate, through its relevant organs, immediately assumes jurisdiction and invites the County Assembly and the County Governor to a consultative process that will restore a functioning government to the people of Kirinyaga County. The area senator, Honorable Charles Kibiru, should lead the various reconciliatory measures to bring together the county executive and the County Assembly and all other institutions in order to restore harmonious working relationship in Kirinyaga County. Mr. Speaker, the committee on the issue of the conduct of the governor. Mr. Speaker, it is worth noting that the committee was unimpressed and must express its reservations on the pattern of conduct of the governor that it has perceived on the basis of the evidence adduced before it. For example, while it is open to the governor to indulge in less important activities, it is an inspiring and disturbing picture when the governor cannot similarly find time to appear before the County Assembly to present the annual state of the county address. The condescending attitude of the governor towards the County Assembly is uncalled for and does not inspire confidence and trust in the county executive leadership. The governor appears to require to be reminded of the high calling of her office and the responsibilities of leadership as set under Article 73 of the Leadership and Integrity Act chapter of the Constitution. Mr. Speaker, the investigation by the special committee, I will go straight to the findings of the special committee, and this is the gist of my presentation. Mr. Speaker, having considered all these matters, it then fell to the special committee to discharge its mandate under Section 33 of the County Government Act, Standing Order 75, and Part 2 of the 5th Schedule, and the Senate Standing Orders, Section 33(4) of the County Government Act, Standing Order 75(2), and Rule 2 of Part 2 of the 5th Schedule of the Senate Order, Standing Orders, mandates the special committee to investigate the matter. Mr. Speaker, the committee's findings on each of the particulars of the allegations are therefore as follows. Charge 1, gross violation of the Constitution and any other law. Mr. Speaker, the first allegation was failure to deliver the annual State of the County Address for the financial year 2018-2019 to the County Assembly. From the evidence adduced before the committee, the governor demonstrated that 2 annual State of the County Address were made. One, albeit, was not delivered in the County Assembly. The committee further noted that there is no county legislation to provide for the content of the annual State of the County Address as required by Section 32K of the County Government Act. The committee also noted that there is no specific law that compels the governor to make the State of the County Address in the County Assembly. The committee therefore finds that the allegation was not proved by law and it is therefore not substantiated. Allegation number 2, undermining the authority of the County Assembly. Evidence adduced before the committee showed that the county executive has always submitted county policy papers and plans, including the county strategy paper, before the County Assembly. Further, the County Assembly has always approved the annual budget, which includes the ADP, the annual development plans, the CIDPs, the fiscal strategy paper, the county outlook papers, Mr. Speaker. There is evidence of plans and policy documents that have been presented to the County Assembly, received and approved by the same County Assembly. The committee therefore finds that the allegation was not proved and it is therefore not substantiated. Allegation number 3, violation of the Public Procurement and Asset Disposal Act 2015 and the Public Finance Management Act of 2012. From the evidence adduced, the committee noticed a clear mismanagement of some tenders. And I want to be very clear on this point, that the committee noted a clear mismanagement of some tender. Of the 12 tenders listed in the motion, the County Assembly only prosecuted 4 of them. The County Assembly used 12 tenders to allege mismanagement in the county, but they only prosecuted 4. 8 were abandoned on the road. Of the 4 tenders prosecuted, the committee notes that there was clear mismanagement of the tender process, where tenders were awarded to companies whose bids were not responsive or where there were clear cases of conflict of interest. The specific tenders in question include tender number CGK ICT 047 of 2017-2018, tender for the design, development, installation, and commissioning of integrated hospital management information system. Mr. Speaker, in this tender, full payment was made long before the user testing was done. And further, the company awarded did not meet the qualifications prescribed in the tender document. The second tender, Mr. Speaker, was the tender for the proposed waterworks for Mwea Makima water projects, March 2018. This tender, Mr. Speaker, was awarded to Ever Trading Agencies Limited, which was clearly owned by a member of the family, specifically the brother to the accounting officer, who awarded the tender with no declaration of interest, yet he's the one who signed on behalf of the county government. In the circumstances, Mr. Speaker, the committee recommends that investigatory authorities undertake investigations on the same and the culpable officers, including the respective tender evaluation committee members, be called to account. The committee, therefore, finds that the allegations were not directly linked to the governor, and it is therefore not substantiated. Charge number 2, abuse of office and gross misconduct. Allegation number 1, violation of Section 46 of the Public Procurement and Asset Disposal Act of 2015. Evidence adduced before the committee showed that the respective tender committees were by law established by the respective accounting officers. There was no evidence linking the governor with the establishment of the tender evaluation committee. The committee, therefore, finds that the allegation was not proved, and it is therefore not substantiated. Allegation number 2 on charge number 2 of abuse of office and gross misconduct. Conferring a benefit to a public officer. Mr. Speaker, from the evidence adduced, the committee established administrative malaise in the management of interest in Kirinyaga County. The committee first took great exception to the county assembly for listing 12 interests paid to the governor and alleging that the governor was issued with interest but never traveled or surrendered the interest. The county assembly, on prosecuting, they only prosecuted 2 out of the 12, Mr. Speaker. Mr. Speaker, again, the county assembly brings 12 allegations and only prosecute 2 and abandon 10, Mr. Speaker. Mr. Speaker, the governor adduced evidence of the travel, and where the travel was never undertaken, the interest was surrendered throughout the time. The committee observes that accounting officers must adhere to the Public Finance Management Act of 2012, which requires interest to be surrendered within 7 days. And in the event of delay, the refund should be made with interest, Mr. Speaker. Mr. Speaker, here, Governor Anne Waiguru was supposed to travel in January, but she refunded the interest in April, Mr. Speaker. Mr. Speaker, as a committee, we noted that that was a malpractice and it should not be entertained, and the accounting officer should ensure that such members of the public service should be surcharged in case they don't remit or account the interest. The committee, therefore, Mr. Speaker, finds that this allegation was proved but does not amount to an impeachable offense. Allegation number 3, Mr. Speaker. Disregard of the recommendation of the County Public Service Board regarding remuneration of members of the board of Kirinyaga Investment Development Authority, payment of KIDA board members outside the IFMIS and county government payroll, and payment of interest amounting to more than 14 million paid to Mr. Francis Muriithi Kariuki. Mr. Speaker, evidence adduced before the committee, and we are talking about evidence, nothing less than evidence. Evidence adduced before the committee demonstrates that payment was made in accordance with Salary and Remuneration Commission circular on payment of allowances to board and commissions. The committee, therefore, Mr. Speaker, finds that this specific allegation was not proved and it is therefore not substantiated. Allegation number 4 on charge number 2, violation of the right to health of the people of Kirinyaga County. From the evidence adduced before the committee, it was established that there was significant systematic problems in the health sector in Kirinyaga that can be addressed by various organs, including the county assembly and the national government institutions. The committee further notes that the high turnover of health workers in Kirinyaga County and the inordinate delay in the payment of health workers who, pursuant to the governor's moratorium, resumed work. This issue should be addressed forthwith. The committee finds that this allegation was again not proved and is therefore not substantiated. Mr. Speaker, you will allow me to conclude.
You have 2 minutes.
Mr. Speaker, I don't know why you are not interested to know how we conclude this matter.
In fact, you know, you've gone over the time I gave you. So you must really...
Mr. Speaker, we have recommended, I'm not able to trace that, but I'll go off the script. Mr. Speaker, the committee has recommended that specific officers who constituted the tender committees, that is the chief finance officer, and members of the tender committees, that is Wayne, Pauline, and the director, supply chain management, Mr. Cornelius Otieno, should step aside as the DCI, the Ethics and Anti-Corruption Commission, and all other prosecutory organs look into this matter, Mr. Speaker. And lastly, Mr. Speaker, all the companies that were awarded unlawful tenders in Kirinyaga County, the EFCC, the DCI, and any other investigatory organ should initiate investigation and report back within 60 days, but in the meantime, those tenders should be paused until that matter is heard and determined. Thank you, and may God bless Kenya. I also want to remind people that I am still the senator for Kakamega County. Thank you so much.